Good evening, class. Tonight's topic is Title 4 of the Revised Corporation Code of the Philippines. We will be talking about powers of corporations. So remember, powers of corporations will refer to the right or capacity of a corporation to perform all acts or things except those which are forbidden by law or the articles of incorporation in order to further the purposes of the said corporation. So remember also that powers of a corporation are exercised through the board of directors or trustees or the officers or the agents of the corporation except otherwise provided or in instances wherein yung approval ng stockholders or members ay kailangan for a specific corporate act. Because remember class, in case of stockholders or members, they keep residual powers to control yung corporation. So please take note also of the doctrine of limited capacity. The doctrine of limited capacity states that ang powers ng corporation ay number 1, those that are expressly granted, and number 2, those which are necessarily implied from the express, and number 3, those which are incidental to the existence of the corporation. So yung enumeration ng mga powers ng corporation as provided for in the revised code implies the exclusion of all other powers except if the power is implied or the power is incidental to the corporation. So yun ang kailangan nating tandaan sa doctrine of limited capacity. Sometimes they ask that in the board exam also. So please take note also of the 3 classifications of corporate powers. Number 1, those expressly granted or authorized by law. So meaning, it is the revised code or the articles of incorporation which confers this power to the corporation. So, express, malinaw na sinabi. Number 2, those that are necessary to the exercise of the express or incidental powers. So, para ma-exercise yung express at saka yung incidental powers, ito yung mga powers na kailangan ng isang corporation. So, number 2 refers to your implied powers. Number 3 naman, those which are incidental to the existence of a corporation. Meaning, by merely becoming a corporation, these are the powers that are given. So, remember also that the powers will cut across lines. Mahirap ikulong sa definition or sa isang classification yung mga powers ng corporation. So, anyway, we will discuss each of the powers separately. So, yung muna tayo sa express powers under Section 35. So, conferred by the Revised Corporation Code and also the Charter of the Corporation. So, remember the Charter of the Corporation will include the Articles of Incorporation and also yung General Incorporation Law, which is the RCCP, or in case of a special corporation, yung special corporation special law which created such corporation. So, ang kailangan yung tandaan sa express powers, they may be exercised by the corporation, whether or not they are powers stated in the Articles of Incorporation or in the bylaws. So, anyway, ito mga to, kahit hindi nyo state sa articles, hindi nyo state sa bylaws, remember, they can be exercised by the corporation because they are provided for in the Revised Corporation Code of the Philippines. How about implied powers? So, implied powers are reasonably necessary to execute the express powers. So, para magawa ang express powers, ito ang mga powers na impliedly given to corporation. So, to accomplish also or carry out the purposes for which the corporation is formed, kailangan ng mga implied powers. Anyway, implied powers are expressly recognized under Section 35K of the Revised Corporation Code. How about, also remember, yung implied powers are classified or binigyan tayo ng mga activities or rough classification which will embrace most of the implied powers. So anyway, acts in the usual course of business. So remember, this will include borrowing money, making contracts, executing promissory notes, etc. So itong mga itong mga powers na to, they are acts in the ordinary course of business of the corporation. They are acts under ordinary circumstances, and they are acts necessary to run a business. What else? acts to protect debts owing to a corporation, meaning here obviously the corporation is a creditor, and these are acts that the creditor, implied acts that the creditor may do in order to protect his right as such creditor. So a corporation may also embark in different business. So but as a general rule, remember, yung pag-engage sa different business, hindi talaga pwedeng gawin ng corporation yan because it can only engage in the purpose for which it was created. Now, but as a temporary part of its business, pwede naman. Temporarily conduct outside business is allowed to corporations. What else? Number 3, 4, acts in part or wholly to protect or aid employees. So, here class, ang view ng mga experts is that yung mga acts to which will favor yung mga employees such as building homes, places of amusement, hospitals, etc. are within corporate powers. What else? Acts to increase business. So, these are part of implied powers again. Ano to? Yung mga pa-contest sa radyo, pa-advertisement, etc. Pa-contest sa TV programs or etc. para lang i-promote yung business ng corporation. So, this is obviously an implied power. But again, no fixed rule can be laid down to mechanically determine yung cases of implied powers. So it is dependent on the facts and the circumstances whether a corporation has the power impliedly to perform yung mga acts na ito. What else? Please take note also of incidental or inherent powers. These are powers which a corporation can exercise merely by being a corporation. So, they are obviously impliedly granted. So, dahil corporation siya, binigay kaagad itong power na to. So, recognize ito under sections 22 and sections 44. So, some of the powers enumerated under section 35, if I'm not mistaken, are actually incidental powers. Pero yun na nga, mahirap kasing define ng mga klase ng powers because they cut across lines. So anyway, other examples of express powers as provided for under this section. Number 1, power to sue and to be sued. Yung power ng isang corporation na magdemanda, and of course the liability of a corporation to be sued. So sabi ng book ninyo, this is an incidental power to corporate existence. Meaning, merely because of becoming a corporation, meron kayong power to sue and merong liability to be sued. So, pagka nagdemanda kayo sa corporation, it is brought against the name of the corporation. If ang corporation magdedemanda, it will file an action in its own name. So, take note also of the application of the power to sue and the liability to be sued. In case of de facto corporation, of course, they may sue or be sued. Bakit? Again, de facto corporations are legally existing as except in the eyes of the state. So, they can claim existence kasi nga may exercise ng corporate powers yan, and there is bona fide intention to incorporate. So, ang de facto corporation, they are considered as corporations except in the eyes of the state. So, anyway, because of that, they may sue, they may be sued. Dissolved corporations, so obviously after the 3-year winding up period, hindi na yan de jure and de facto. So, after that period, it cannot sue anymore or it cannot be sued anymore, subject to exceptions which we will learn later on when it comes to the liquidator ng mga dissolved corporations na yan. Unregistered corporations, obviously they are not they do not have juridical personality, so they cannot legally sue as such. What else? Pwede ba silang idemanda? Yes, based probably by they are considered as corporations by estoppel. So ang liability dyan is that of general partners. In case of foreign corporations, so remember, foreign corporations which do not have license to transact business in the Philippines cannot sue in the Philippines. except in some cases. So, anyway, mag-aaralan natin lalo yung foreign corporations when we go to Title 15. What else in case of moral damages? So, tandaan nyo, in corporation, hindi siya as a general rule entitled to moral damages because moral damages is paid due to, as you can see here, physical suffering, mental anguish, besmirched reputation, or nasirang reputasyon, or such as sentiments as wounded feelings, serious anxiety, moral shock, social humiliation, and other similar injuries. But here, remember, a corporation does not feel these things. Wala siyang physical suffering, mental anguish, etc., etc. So, as a general rule, it cannot claim moral damages, except if a corporation has a good reputation as already provided here, or business standing. And yung kanyang reputation or business standing, if na-besmirch yan or na-debase or nasira ang kanyang reputasyon, it can result to social humiliation. And pwede siyang ma-awardan ng moral damages, but only in this case. So, kailangan niyang establish na meron na siyang reputasyon and nasira yung kanyang reputasyon, which caused social humiliation and caused damages to the corporation. What else? Also, the power to adopt and use a corporate seal. Please take note of the definition of a seal: a device, an emblem, symbol, or word used to identify or replace the signature of an individual or an organization, and to authenticate written matter emanating from such individual or organization. So, it may also refer to an impression of the device, which are placed upon documents like certificates of stock. So, what you have to remember about seal is any seal may be adopted and used by a corporation. So, kung meron silang inadopt na seal, pwede nilang, gagamitin nila yan obviously because they adopted it, but they can also alter it at pleasure. So, pwede nilang palitan anytime. So, pagka nag-adopt ang corporation ng seal for a special occasion, etc., halimbawa 100 years anniversary, pwede silang mag-adopt ng special seal, which is different from its customary corporate seal. Usually, these are valid only for the specific time and occasion, kung kailan ginamit yung seal for special occasion na yan. Also, remember that a seal is not required for the validity of a corporate act. Usually, yung seal ginagamit yan sa mga certificates of stock. But kung walang silang certificate of stock, okay, walang problema yon because this rule is merely directory, not mandatory. So, it's not required to put yung seal, to seal yung mga certificate of stock. And a corporation may even exist without a seal. What else? Bakit kailangan ng seal? Siguro maganda na rin para magkaroon ng prima facie presumption that the instrument is an act of the corporation. That's why okay na rin, desirable to attest all contracts and other acts of a corporation with its own seal, if possible, if they have a seal. What else? Also, please take note of the power to acquire and convey property. Again, this is an inherent power in the corporation. Alangan namang hindi sila magkaroon ng property by which they can conduct their business. So, any property acquired by the corporation is placed in the name of the corporation. Any property conveyed by the corporation will be conveyed using the name of the corporation as well. So, what else? Of course, yung property na bibili niya is necessary to the transaction of its business. So, yung property which is obtained by a corporation which is foreign to the purposes for which it was organized is unlawful acquisition. So, pagka bibili siya ng property, dapat may kinalaman sa business niya. Dapat magagamit niya sa purpose niya. But if not, remember, if it is foreign to the purpose, it is considered as an unlawful acquisition. Also, remember that yung kanyang right to own property is subject to limitations or restrictions prescribed by special laws and also the Constitution, which you can read in your book. Nasa book niyo naman yan. What else? Please take note also of the power to acquire shares or securities. So, shares or securities of other corporations. So, shares of stock ng ibang corporation pwedeng i-acquire yan ng isang corporation. So, Corporation A will buy shares of stock of Corporation B. So, if merong, if gusto ng corporation na gawin yon, pwede. So, it does not need the approval of the stockholders if it is done in pursuance of the purposes or purpose of the corporation. So, kung nakalagay sa articles that the corporation will invest, will buy shares of stock in other corporations, kung kasama yan sa purposes ng corporation, pwedeng gawin yan even without the approval of the stockholder. But now, if it is not one of the purposes of the corporation to acquire shares of stock in other corporations, and this is done solely for investment, approval of stockholders will be required under Section 41 of the Code. What else? Obviously, yung corporation can also acquire its own shares of stock subject to the limitation that bago bilhin ng corporation ang kanyang sariling shares of stock, it is based on the limitations stated by law. Meron kasing grounds yan which we will study later on under Title 7. And also, it has unrestricted retained earnings to cover the shares to be purchased or acquired. What else? Power to enter into partnership. So, this is actually new. Only sa revised corporation code ito. So, before, a corporation cannot enter into a partnership kasi nga yung corporation may be bound by people who are not a part of the board of directors, but the revised corporation code expressly allows now yung yung corporations to enter into a partnership. However, my concern here is that yung partnership may be bound by persons who are not partners to the partnership and may be bound by persons with whom they do not have mutual trust and confidence. So, this is my problem with this provision. But obviously, because it is expressly provided by law, wala na tayong magagawa dyan. So, the revised code now expressly gave corporations the power to enter into partnerships. Dati, pwede lang joint ventures and also they can enter into limited partnerships. How about another power which is provided by Section 35, power to contribute to charity. So medyo iniba nila to from the old code. So ang mga corporations not only for profit making, meron din silang corporate social responsibility to aid in the betterment of the economy and social conditions. Blah blah blah, alam niyo na. So anyway, the limitation on the power to contribute to charity is that number 1, the amount must be reasonable. And number 2, no foreign corporation shall give donations in aid of any political party or candidate or for purposes of partisan political activities. So, before class, bawal mag-donate ang corporations, domestic or foreign, to any political party or candidate. Ngayon, because of this amendment, obviously, yung domestic corporations can now donate to political parties, to candidates, and also for purposes of partisan political activities. Anyway, kailangan lang naman daw talaga is the donation must be reasonable. So, what else? Power to establish pension, retirement, and other plans. So obviously, Section 35 will grants this authority to corporations because it is for the benefit of officers and employees. So pagka kasi merong nag-establish ng pension, retirement, and other plans ang mga corporation, it promotes the purposes for which the corporation was formed. Yan. So, anyway, those are the express powers as provided for in Section 35. So, other express powers of corporations are found under Sections 36 up to Section 43. So, in Section 36, it talks about the power to modify the corporate term. So, the corporate term may be extended or shortened. Remember, yung corporate term na tinutukoy natin dito is hindi yung perpetual na corporate term. In terms of extending, kasi hindi mo na may extend yung perpetual. But obviously, you can shorten it. Now, if your term is fixed, yung fixed term can also be extended and can be shortened. It can likewise be shortened. So, yun ang kailangan yung tandaan muna dyan sa power to extend or shorten corporate term. So, the extension or shortening of corporate term may be made by an amendment to the Articles of Incorporation. And remember, such amendment must be approved by the majority vote of the board and also ratified at a meeting of the stockholders representing at least 2/3 OCS and 2/3 of members in case of non-stock corporation. So, usually class, ang Section 15 which governs amendments in general, it allows amendment, kasi di ba may amendment dito, it allows amendments by mere assent of the stockholders or members. However, class, in Section 36, mere written assent is not sufficient. Kailangan merong meeting to approve yung extension or shortening of corporate term. Also, please take note that yung extension or shortening of corporate term is not effective upon approval of the SEC kasi meron nga namang date na nakalagay dyan. So, also, voluntary dissolution may be made by shortening of the corporate term. And what else? Yung extension of corporate term is subject to the provisions of Section 11, in which case extension cannot be made earlier than 3 years prior to the expiration of the date of the corporate term as originally stated in the Articles of Incorporation unless there are justifiable reasons as may be determined by the SEC. Now, the requisites to extend or shorten the corporate term is majority vote of the BOT, 2/3 OCS or 2/3 of the members. What else? Meeting called for such purpose. So, remember, kailangan talaga ng meeting. So, before the meeting, obviously, there should be written notice of the proposed action, and also the time and place of the meeting shall be sent to the stockholders or members at their residence, provided in the books of the corporation or deposited to the addressee in the post office, or served personally, and when allowed in the bylaws or done with the consent of the stockholders, it may be sent electronically. So, if stockholder is not interested in the extension or shortening of corporate term, he may exercise his appraisal right. So again, the appraisal right is the right to demand the fair value of his shares. It's a right of the stockholders to demand fair value of their shares because of a substantial change in the organizational setup of the corporation not contemplated by him during the time he made his investments in the corporation. So, yung time na nag-invest siya, he's not expecting that the corporate term will be extended. So, siya naman, ayaw niya yung extension na yan, he can exercise his appraisal right subject to the rules as found in Title 10. So, anyway, appraisal right is available to dissenting, meaning ayaw niya yung proposed corporate action. So, right is available in case of extension. Right is available also in case of shortening. And obviously, appraisal right applies only to a stockholder of a stock corporation. Now, Section 37 talks about the power of a corporation, two powers of a corporation. The first is the power to increase or decrease capital stock, and the next one is the power to incur, create, or increase bonded indebtedness. So, we will first discuss yung power to increase or decrease capital stock. So, yung increase or reduction in the capital stock, remember, is a fundamental change in the corporation and is granted only because yung power na yan is given expressly by Section 37. However, this power has limitations. So, generally, a corporation cannot lawfully decrease the capital stock if it will have the effect of relieving existing subscribers from the obligation of paying their unpaid subscription without valuable consideration. So, hindi pwedeng i-release yung mga may balance na mga stockholder without valuable consideration. Also, no decrease in the capital stock will be approved if it shall prejudice the rights of corporate creditors. So, yun ang limitation sa power. Number 2, a corporation cannot issue stock in excess of the amount limited by its Articles of Incorporation. So, kung may shares of stock, tapos meron tayong capital stock, kung halimbawa ang shares of stock na issued ng corporation is only, ang nakaset sa articles nila is only 100, they cannot issue more than that. So, unless there is an amendment of the articles of incorporation. So, kung ano yung limit, yun lang ang pwedeng i-issue ng corporation. What else? Reduction or increase in the capital stock can only take place in the manner provided by law as prescribed in Section 37. And also, remember that the revised code does not prohibit a corporation to increase its authorized capital stock even if the same is not yet fully subscribed. So, yun ang kailangan yung tandaan. It is a power granted by Section 37 subject to limitations also. What else? Now, why is it necessary to increase yung capital stock? Because remember, if you increase your capital stock, you increase also yung corporate assets. So, yung increase of corporate assets may be affected by, number 1, authorizing the creation of new shares to be offered and issued at a fixed valuation. And number 2, you can increase the par value of already existing shares authorized to be issued. Now, also, pwede mo namang increase yung capital stock mo by issuance of stock dividends. Now, if you issue stock dividends, capital stock is increased without corresponding increase in the corporate assets. Kasi yung stock dividends, remember, are profit on the part of the stockholders. Now, the subscription requirement for increase in the capital stock. So, you have to remember that Section 37 requires that at least 25% of such increased capital stock has been subscribed. Or so halimbawa class ang iyong capital stock is I think the example in your book is like 200,000, that is your authorized capital stock. Yun ang authorized capital stock mo, 200,000 pesos. So if you want to increase it, let us say your subscription is let us say 100,000. So 200 ang iyong authorized capital stock. Yung subscribed capital mo is 100,000. So, yun ang naibenta mo na capital stock. Also, ang paid up nun, let us say, fully paid 100,000. Then, yung fully paid yung subscription. So, ulitin ko 200,000 ang yung authorized capital stock, 100,000 worth ang yung subscription, and ang paid up is also 100,000. So, sa maka-trade class, lahat ng naibenta mo, nabayaran siya, paid up siya. So anyway, if you want to increase your capital stock, remember class that new subscription may be required, or it can also happen that no new subscription will be necessary. So it depends doon sa iyong subscribed capital and also paid up capital. But what you have to remember is that pagka nagkaroon ka ng increase in your capital stock, Section 37 will require that at least 25% of the increased capital has been subscribed na bili. Yun lang naman ang nire-require niya. So let us say class, your authorized capital stock is 200 nga. Tapos ang na-subscribe is 100. Paid up din yung 100 na yan. So you will increase your authorized capital stock to 500,000. So this is an increase of 300,000. Now remember class, unrequired is that yung new authorized capital stock mo, dapat 25% nun ay naka-subscribe. So ang ika-count mo dyan is yung 500,000. So now if 25% of 500,000 is considered, dapat ang subscribe mo is 125,000 pesos. So ngayon, obviously, kailangan mo magbenta ng mga shares para makuha mo yung subscribe na para makuha mo yung 125,000. Because remember, kailangan yung increased capital stock should be subscribed 25%. So, new subscriptions are necessary. Kailangan mo magbenta ng bagong shares. Now, what if same problem, except that yung authorized capital stock mo is, let us say, 200,000. Your subscribed is 150,000 pesos. Now, yung 150,000 pesos mo yan, let us say, pwedeng kalahati na bayaran, etc. Now, itong corporation na to, in-increase nila ang kanilang capital stock from 200,000, in-increase nila to 500,000 pesos. Again, ang kailangan yung tandaan is that yung increased authorized capital stock, the law requires that 25% of it must be paid. So ngayon, kailangan yung must be subscribed. So ngayon, kailangan yung 500,000 na increase, dapat ng 25% ay subscribe. So, halagang 125,000. But if you remember class already, nandoon sa original authorized capital stock mo, ang yung subscribe ay is already 150,000. So, kailangan mo po bang magbenta ng bagong shares? Hindi na. Kasi doon pa lang sa original subscription mo, doon sa 200, nakuha mo na yung 25% para doon sa 500,000 pesos. So, remember, in this case, no new subscriptions are necessary. So also take note of the ways of increasing or decreasing authorized capital stock. So you can increase the number of shares authorized or decrease the number of shares authorized. Let us say 1 million ang yung authorized capital stock, tapos meron kang binebentang 100,000 shares. So yung 100,000 shares mo, pwede mong gawin siyang 200,000. So in-increase mo yung number of shares authorized. So hindi mo naman i-increase yung par value. Here, remember the par value of each share is 1 million. 1 million divided by... So, 10 pesos per share. Diyos ko, kinalculator ko pa yun. Alam niyo naman, class, hindi tayo accountant. So, anyway, 10 pesos per share. So, remember, you did not increase the par value of the shares, but you increased the number of shares. From 100,000, ginawa mo siyang 200,000 shares. So obviously, your authorized capital stock will increase also to 2 million. So what else? Also, pwede mo naman siyang i-decrease. So yung 1 million na authorized capital stock mo, tapos divided into 100,000 shares, imbis na 100,000 shares, pwede mong gawing 50,000 shares na lang. So same par value, 10 pesos. But remember here, class, that your authorized capital stock will become 500,000 pesos na lamang kasi 50,000 shares times 10 yung par value ng bawat share. So, yun ang kailangan yung tandaan. Increase the number of shares without increasing or decreasing the par value. Number 2, you can increase the par value without increase or decrease the par value without increasing or decreasing the number of shares. So, your authorized capital stock again is 1 million at meron kang in-issue na 100,000 shares at 10 pesos per share. So, ang ginawa mo, bawat isang share ay in-increase mo. From 10 pesos, ginawa mo siyang 20 pesos per share. So, remember, if 20 pesos per share times 100,000 shares, yung authorized capital stock mo magiging 2 million pesos. So, here, hindi mo in-increase yung number of shares, but in-increase mo yung par value ng bawat isang share. Same is true with decreasing. Instead na 10 pesos, ginawa mo na lang siyang 5 pesos per share. So, 5 pesos per share times, remember, 100,000 shares, yung iyong authorized capital stock, i-decrease mo to 500,000 pesos. And number 3, pwede mong increase or decrease both number of shares and authorized to be issued and also the par value thereof. What else? Please take note also of the effect of reduction on liability for unpaid subscription. So, remember, a corporation has no power to decrease the authorized capital stock to relieve yung mga existing stockholders of their liability for unpaid subscription without valuable consideration, as I've already mentioned before. So, also, kailangan ding tandaan nyo na pagka nagkaroon ng increase or decrease in the capital stock, lalo na sa decrease, it requires corporate meetings para ma-publicize yung intention ng corporation to reduce its capital stock. So, also, please take note of distribution of surplus in case of reduction. If there is no impairment of capital, remember class, na pwedeng i-distribute, ay pwedeng mag-distribute ng surplus. Now, if reduction is made to meet impairment, remember class, that hindi pwedeng kasi walang surplus so wala siyang i-distribute. And remember also that the distribution here of surplus is not mandatory. If the corporation wants to keep the surplus, pwede naman. as profit yan. So anyway, meron namang example sa book ninyo, tignan nyo na lang ng mabuti. Also, the requisites to increase or decrease capital stock, majority BOD, ratification by 2/3 OCS. Obviously, we are talking about only of stock corporations here. Meeting, so in the meeting, there is written notice, time, place, meeting, purpose of the meeting, also sent to the stockholders personally by mail or by electronic means. Also, certificate signed by majority of the directors of the corporation and countersigned by the chairperson and secretary, setting forth, number 1, that they have complied with the requirements of Section 37. Number 2, amount of increase or diminution of capital stock. If it is the increase of the capital stock, kailangang ilagay dyan yung names, nationalities, subscription ng mga bagong stockholder, yan, amount subscribed by each, etc., etc. What else? Amount of stock represented during the meeting and the vote authorizing the increase or diminution of the capital stock. In addition to the certificate, remember, the treasurer must also submit a treasurer's affidavit or sworn statement na sinasabi niya na 25% of the increased capital stock has been subscribed. Yan. And 25% of the amount subscribed has been paid to the corporation. So, and also a certificate of filing will not be accepted if there is no sworn statement. Obviously, in case of decrease, hindi na kailangan ng treasurer's affidavit. How about effectivity of the increase or decrease? So remember, it is effective if it is approved by the SEC and were appropriate if it is approved by the Philippine Competition Commission. So the application to the SEC must be made 6 months from the date of approval by the BOD of the increase or decrease in the capital stock. So yung certificate will be kept in the office of the corporation and also 1 copy will be filed with the SEC. Yan. So pagka inapprove ng SEC yon, i-issuean sila ng certificate of filing. What else? Power to incur, create, or increase banded indebtedness. So yung banded indebtedness, please take note of the definition. Written promise by a corporation to pay a definite sum of money at some future date, fixed rate of interest, given in return for money or its equivalent received by the corporation. Sometimes secure, sometimes not. So here, nangungutang ang corporation and the corporation issues bonds to yung mga creditors. So remember, the power to incur, create, or increase banded indebtedness is available to both stock and non-stock corporation. Pwede namang mangutang ang non-stock corporation. Obviously, a stock corporation pwede na mangutang yan for the to pursue its business. What else? Also, shares and members entitled to vote. Even holders of non-voting shares, non-voting members are entitled to vote in case of incurring, creating, or increasing banded indebtedness. What else? Prior approval of registration of bonds with the SEC. So, kailangan yung mga bonds na i-issue is registered with the SEC and approved by the SEC. What else? Requisites to incur, create, increase banded indebtedness, majority BOD or trustees, pwede na ngayon ng trustees kasi pwede nga mangutangan non-stock, 2/3 OCS, 2/3 members, meeting, blah blah, remember yung mga requisites sa meeting, notice, etc., sent to your stockholders or members, and also a certificate signed by majority of directors, trustees, countersigned by chairman, chairperson, secretary, etc., and number 1, that the requirements, ano nakalagay sa certificate, that they have complied with the requirements of this section, banded indebtedness to be incurred, created, or increased, amount of stock represented, and vote authorizing the increase, creating, or increasing of any banded indebtedness. Now, when is the banded indebtedness effective? Upon approval of the SEC or where appropriate, again, the Philippine Competition Commission. So, same rules as before. So how about the next right? Yung right to the right power to deny pala, preemptive right. So first, before we deny yung preemptive right, tignan muna natin ano ba kasi yung preemptive right. So the right of preemption or preemptive right is the right of a stockholder who are such at the time of increase of the capital stock of a corporation to be first offered new shares of stock issued in proportion to their existing shareholders and on equal terms with other holders of the original stocks before subscriptions are received from the general public. So remember class that the right of preemption or preemptive right is i-offer muna sa isang stockholder, existing stockholder, yung mga bagong issue ng shares of stock before they are offered to the general public. So what is the purpose of preemptive right? To safeguard yung right ng stockholders and to preserve yung kanilang or unimpaired, unaltered yung kanilang proportionate influence and interest in the corporation and relative value of yung kanilang stock holdings. So let us say class 100,000 shares ang isang corporation. Tapos si A may owner siya ng 51,000 shares. So obviously A is a majority stockholder. Now itong si A, this corporation, let us say increases yung kanilang capital stock to let us say 200,000. So kung hindi bumili si A dun sa 200 sa increase na 100, yung kanyang stock subscription remains at 51,000 out of 200,000 shares. Obviously A is no longer there is a possibility that A is no longer majority stockholder. Now to prevent this, remember that A can should be offered first 51,000 shares doon sa bagong issue na 100,000 shares. So in proportion to his existing stock ownership, yun ang preemptive right. So yun ang offer sa kanya for A to be sure na i-maintain niya yung kanyang proportionate interest of 51% doon sa corporation. So yun ang kailangan nating tandaan sa preemptive right. Now obviously if preemptive right is a right given to stockholders, it can also be denied. So power to deny preemptive right is provided for in yung may be denied in case by the articles of incorporation or an amendment thereto. So remember, it can be denied by the articles or an amendment to the articles, and or if it falls under any of the exception. So if hindi naman siya denied, hindi naman siya nalaglag dun sa exceptions, yung mga stockholders are allowed to exercise yung preemptive right. So obviously you have to identify ano ba yung shares which are exempted na hindi pwedeng i-apply yung preemptive right. Number 1, shares specified by law. So shares to be issued in compliance with laws requiring minimum stock offerings to the public. So here class, preemptive right will not extend to shares which are issued to comply with the legal requirement. What else? Number 2, in case of shares issued in good faith with the approval of stockholders representing 2/3 OCS in exchange for property needed for corporate purposes. So here, bumibili ng property ang corporation and ang gagamitin nilang pambayad is shares of stock. So walang preemptive right dyan. Number 3, yung shares issued as payment for previously contracted debt. So may utang ang corporation, tapos they will issue shares with the approval of 2/3 OCS. Tapos yung mga shares na in-issue nila, new shares will be used to pay yung previously contracted debt. So obviously here, to convert liability into capital, new shares must be issued by the corporation by amendment of the articles of incorporation. Anyway, we already studied how to increase yung capital stock. Yan. So also, remember that the remaining unsubscribed shares, ito yung hindi bago, pero hindi siya inoffer initially. So let us say 100,000 shares, ang inoffer lang is 50,000. So meron siyang 50,000 unsubscribed shares remaining yan sa corporation. So it may be offered to the public or any acceptable any person acceptable to the corporation. Pagka yung mga unissued shares, whether from original or increased capital stock corresponding to one stockholder, hindi niya inavail yung kanyang preemptive right, it is deemed waived. So, what else? Number 2, also stockholders of record, public policy, and sound corporate practice. Kung hindi inavail yung preemptive right as to newly issued shares or unissued shares, original unissued shares, maganda na rin sound corporate practice to offer it to existing stockholders before it is offered to the public. But here, in case of existing stockholder, hindi naman kailangan in proportion to their stock holdings. What else? As to treasury shares, remember, mayroong preemptive right in both open corporations and in closed corporations. Ang haba ng discussion, but the ending is, remember class, available ang preemptive right to treasury shares. What else? The power to dispose of all or substantially all of corporate property. So please remember SLEMPO, sell, lease, exchange, mortgage, pledge, or otherwise dispose of all or substantially all of the property of a corporation and assets, including the goodwill. So this is covered by Section 39. So here, remember, yung corporation may dispose of all or substantially all of the corporate property by action of the board of directors or trustees and supported by the required vote of the stockholders or members. Now, before dispose yung all or substantially all of the corporate property, there must be a fundamental change in the corporation which would warrant the selling or disposition of all or substantially all of its property. Here, the approval of the SEC is not required. So, yan. So, requisites for the validity of the sale. So, remember, written notice of the proposed action, time, place, and meeting, etc. to the stockholders, served personally or through the post office or electronically, kung it is provided in the bylaws or with the consent of the stockholder. Approval by majority BOD or BOT. And number 3, authorization of 2/3 OCS or 2/3 of the members. Yan. Obviously, yung in case of yung disposition is necessary and usual in the course of the business, remember the stockholders consent or ratification is not required. So, also, if the proceeds of the sale or other disposition of such property and assets will be appropriated for the conduct of remaining business, hindi na kailangan ng ratification ng stockholders or members. And of course, class, the dissenting stockholders can exercise yung kanilang appraisal right if they are not amenable to the disposition of all or substantially all of the corporate assets. The next power of corporation provided by Title 4 is the power to acquire own shares. So remember, class, before a corporation will acquire its own shares, it is subject to certain rules. So kailangan nating tandaan na the limitation is that the acquisition is for a legitimate corporate purpose and that there are unrestricted retained earnings in the book to cover the shares acquired. So, first, before we learn of unrestricted retained earnings, tignan muna natin ano muna yung retained earnings. So, retained earnings are accumulated profits realized out of normal and continuous business operations after deducting therefrom distributions to stockholders and transfer to capital and other accounts. Now, yung retained earnings will be unrestricted if they have not been reserved or set aside by the board of directors for some corporate purpose. So, kung wala siyang pinaglalaanan na corporate purpose, hindi itong retained earnings na to will be considered unrestricted. And because they are unrestricted retained earnings, they may even be available for dividend distribution. Now, instances when a corporation may acquire its own shares. Number 1, to eliminate fractional shares. So, these are shares less than 1 share. Para nga naman mabuo itong shares na to, bilhin na lang nila yung mga fraction ng mga shares. Usually, this happens when there is issuance of stock dividends. What else? To collect or compromise an indebtedness to the corporation arising out of unpaid subscription in a delinquency sale and to purchase delinquent shares sold during said sale. So, remember, para reacquire yung mga unpaid shares and delinquent shares, it is the power of the corporation also. What else? Number 3, to pay the dissenting or withdrawing stockholders entitled to the payment of his shares. So here in number 3, itong dissenting or withdrawing stockholders, especially the dissenting ones, they exercise their appraisal right pursuant to Title 10. So ito, pwede yung mga kanilang mga shares na pag-aari ng mga dissenting stockholders, bibilin ng corporation yan to acquire treasury shares also, to acquire redeemable shares, and to effect a decrease in the capital stock of the corporation. Yan. And last one, in case of deadlock in management of a corporation. So this will refer to your closed corporation. The SEC may order the purchase at their fair value of the shares of any stockholder by the corporation, regardless of availability or unavailability of unrestricted retained earnings in the books. So, pagka may deadlock na sa management ng closed corporation, SEC will just order the corporation to buy shares of stock of any stockholder, even if there are unrestricted retained earnings or not. So, this is an exception. So, the conditions to exercise the power to acquire own shares: there is no impairment of capital. It is for a legitimate purpose. There are unrestricted retained earnings except in cases of redeemable shares, which we have already studied under Section 8, if I'm not mistaken. Even if there are no unrestricted retained earnings, pwede nating i-redeem yung redeemable shares, provided it will not render the corporation insolvent. And also, in case of a closed corporation, which I just mentioned a while ago, corporation acts in good faith and does not prejudice the right of the creditors, and the corporate condition warrant it. So, remember, these are the conditions for the acquisition of the own shares of a corporation. Please take note also of the trust fund doctrine, always asked in the board exam. Assets of a corporation, as represented by its capital stock, are trust fund, which are to be maintained unimpaired and to be used by the corporation to pay corporate creditors, in the sense that there can be no distribution of assets among stockholders without provision being first made for the payment of corporate debts. So, yung capital stock ng corporation, pambabayad muna ng utang. Hindi pwedeng i-distribute yung mga assets without first paying for the corporate debts. So, bakit? Kasi baka ma-prejudice yung mga creditors. Yan. So, in case of purchase of a corporation's own share, kasi remember, class yung assets ang ginagamit dyan. So, in case of kung walang unrestricted retained earnings and there is purchase of own shares of the corporation, it violates yung trust fund doctrine. How about the power to invest funds in another corporation? So, remember here, class, that in Section 41, pwedeng maraming purposes ang isang corporation. But, yung kanyang investment ng kanyang funds is obviously for the primary purpose. Now, pwede ba siyang mag-invest ng corporate funds in other purposes? The answer is yes. But in order that it may invest funds in another corporation or business other than the primary purpose, it must comply with the requirements of Section 41. So, what are the requisites? We will go to the requisites later on. So, also remember here that the corporation may invest funds in another business which is incident or auxiliary to its primary purpose without approval of the stockholders. So, if it is auxiliary to the primary purpose, kasi may kinalaman sa primary purpose na to as stated in the Articles of Incorporation. So, pwede, even without complying with the requirements under Section 41. And in this case, the dissenting stockholder will not even have any appraisal right. So, again, the requisites to the requisites to in case of investing corporate funds in another business is number 1, there must be approval of majority board of the board of directors or trustees, and to accomplish the primary purpose, approval of the majority of the board of directors or trustees, and the approval of the stockholders no longer necessary. Now, if the purpose is to accomplish, purpose is to invest in another business or other than the primary purpose, there must be approval of the majority BOD and ratification of 2/3 of the outstanding capital stock or 2/3 of the members in case of non-stock corporations. And in number 3, meeting called for the purpose. So please take note of the notice requirement as I have already been mentioning. Now, if it is investment to accomplish the primary purpose, remember class, hindi na kailangan ng approval ng stockholders or members, and also there is no appraisal right even if ayaw ng stockholder na mangyari ito. And if it is for accomplishment or investment in another business or corporation, remember kailangan ng 2/3 OCS and 2/3 of the members. And also in case of number 2, yung other business, other corporation ang pinag-investan, appraisal right is available to the dissenting stockholders. Another power of a corporation is the power to declare a dividend. So please take note of the definition of dividends. Dividends are that part or portion of the profits of a corporation set aside, declared, in order to be paid by the directors for distribution among stockholders at a fixed time. So this is a return of the investment of the stockholders, and it is a characteristic of dividends that it will be paid based on the investment of each stockholder to the corporation. So the power to declare dividends is covered under section 42. So please take note here, in case of dividends, it is paid only out of unrestricted retained earnings, which shall be payable in cash, property, or stock to stockholders on the basis of outstanding shares held by them. So we have already defined what retained earnings are. We have already defined what unrestricted retained earnings are. So alam na natin yan. Earlier provisions we have already discussed. What else? Please take note of the requisites for declaration of dividends. So for declaration of dividends other than stock dividends, ang requirements is majority of the quorum of the board of directors sufficient to declare other dividends. So hindi na kailangan ng approval ng stockholders. So the dividends will be paid to the registered owners of stock as of record date. Now remember, kailangan again ng unrestricted retained earnings, hindi pwedeng wala. Now, what else? In case of stock dividends, there are additional requirements. In addition to the approval of the resolution by the board of directors, kailangan din ng approval ng resolution by the vote of 2/3 of the OCS in a regular or special meeting called for the purpose. Also, for declaration of stock dividends, kailangan mayroong sufficient authorized unissued shares for distribution to stockholders. Siyempre, magde-declare ka nga naman ng stock dividends, wala ka namang i-distribute na stock. Otherwise, if the shares of stock are insufficient, there must be increase in the capital stock of the corporation para meron siyang i-distribute as stock dividends. What else? Also, please take note of the rules in the declaration of dividends. So the rules in the declaration of dividends, general rule is that it is discretionary on the part of the board. They will decide whether or not they want to declare dividends. Now also the exception, surplus profit is in excess of 100% of their paid up capital stock. Kailangan mag-declare ng dividends because this falls under the exception. Now in case of the exception to the exception, kailan to? Dividends is in excess of 100% of their paid up capital, but the corporation is allowed not to declare dividends in case number 1, justified by a definite corporate expansion project approved by the BOD. Also, corporation is prohibited under any loan agreement with any financial institution or creditor to declare dividends without the consent, and consent has not been obtained as of yet. And number 3, retention is necessary under the circumstances, usually special reserve for probable contingencies. So yun ang exception to the exception. Please take note also of the rules regarding payment of subscription from dividends. Yung number 1, usually yung dividends, again, binabayaran yan from unrestricted retained earnings. And yung subscription nyo, usually, pagka no par yan, fully paid yan. Pero pagka par value yan, pwede kasing mag-iwan ng balance. Now, yung balance mo, syempre may subscription ka, may balance. So, pwede mo bang bayaran yan using dividends? That is the question in this section or topic. Now, in number 1 class, if there is a stipulation do sa subscription contract that the subscription is payable from the first dividend declared on any or share, wala kang binayad, pero yung dividends, yun ang ibabayad mo. So, pagka nag-declare ng dividends, that is the time you will pay your subscription until the full amount of the subscription has been paid. So, bawat may dumarating na dividend, dun mo lang babayaran yung iyong subscription. Remember, this stipulation in the subscription contract is illegal. Kasi nga naman, parang wala ka namang nilabas na pera. Kumbaga, bumili ako ng shares of stock sa'yo, wala akong binayad. Hinintay kong may kitain yung shares of stock ko, tapos yung kinita ng shares of stock ko, yun ang ibinayad ko sa'yo. E di parang ewan naman, parang niluto yung corporation sa sarili niyang mantika. That's why this is an illegal stipulation in the contract. So, pagka walang kinita yung dividends, edi wala nang babayaran yung stockholder dun sa kanyang subscription. This is, remember, illegal. So, yung stipulation like this are illegal stipulations. What about payment of the balance of the subscription from cash dividends? So, it depends whether or not the stockholder is delinquent, but later on you will see that it's the same. In both cases, remember, the stockholder is entitled to receive dividends. Now, if delinquent, yung dividends will be first applied to the balance of the subscription. So, may balance lamang. May binayad naman, pero may balance. Plus cost plus expense. So, dun muna i-apply yung cash dividend dun sa unpaid portion ng shares if the subscription is delinquent. Now, number 2, if the subscription is not yet delinquent, although meron ngang balance, yung cash dividends cannot be withheld. So, ibibigay mo yan sa stockholders. Bakit mo ibibigay? Hindi naman delinquent. Hindi lang nabayaran lahat. And remember, the basis here of declaration of dividends or distribution is the entire subscription. So, kung halimbawa ang kanyang subscription is 1,000, halagang 1,000, ang nabayaran lang is 500. Ang basis ng dividends is not 500 na nabayaran niya, but the basis of dividends is yung 1,000 na total subscription niya. So, yun ang tandaan natin pagdating sa subscription. What about from stock dividends? So, in case of stock dividends, remember class, stock dividends cannot be distributed until yung subscription is fully paid. Yan, fully paid. Kailangan fully paid daw siya. Sinubukan kong ituro. Ayan, fully paid. What else? Please take note also of the classes of dividends. I-ano ko na lang. I will just run by them. Cash, payable in cash, property, etc. You should know all of this. They are all in your book. I'm trying to condense this lecture class, so I will just run through them. But remember, cash dividends, property dividends, kailangan lang ng vote ng quorum ng board. In case of stock dividends, kailangan ng approval also of 2/3 OCS. Optional, they have the option to receive cash or stock. Composite, remember, partly in cash, partly in stock. What else is important? Cash, property. So, these are the other kinds of dividends. Please read them para hindi na tayo mahirapan. So, ano pa ba? So, please take note also of the differences between cash dividend and stock dividends, and also bond scrip dividends. So I think that's it for dividends. So another power of a corporation is the power to enter into management contracts. So remember the definition of a management contract. It is a contract whereby a corporation undertakes to manage or operate all or substantially all of the business of another corporation, whether such contracts are called service contracts, operating agreements, or otherwise. So here, class, the corporation will delegate the management of its affairs to another corporation for a certain specified period of time. So also, please take note of the power to enter into a management contract. A management contract may be entered into with another corporation or with a parent corporation. So if it is with another corporation, obviously this is allowed even without the need for of amending the articles of incorporation. Also, in case of a parent corporation, anyway, a parent corporation controls yung affairs naman talaga ng isang affiliate or subsidiary, kaya ay ng isang subsidiary. That's why parent corporation may enter into management contracts with a subsidiary. What else? Also, with natural persons, this is not contemplated under Section 43. So it will apply only to management contracts entered into by a corporation with other corporations. So please take note of the limitations of the power. So ratification of the contract must be approved by majority of the quorum of the BOD and ratified by the prescribed vote of the outstanding capital stock. When I say prescribed vote of the outstanding capital stock, kasi iba-iba ang botohan when it comes to the managing and the managed corporation. So anyway, ito yung mahirap na pagkakasabi, but obviously I can illustrate it for you. So the general rule is this one. Obviously, there's a managing corporation and also a managed corporation. In case of a board of directors and the stockholders, pagka general rule tayo mag-apply, majority of quorum, and in case of stockholders or members, majority of the OCS or members in both managing and managed corporation. However, there are qualifications as provided for in Section 43. Now, if there are interlocking stockholders who own more than 1/3 of the outstanding capital stock, so remember, more than 1/3 of the outstanding capital stock, with voting rights in the managing corporation, mag-iiba yung boto. So, yung BOD, pareho pa rin. Yung stockholders, pareho pa rin on the part of the managing corporation. But on the part of the managed corporation, 2/3 outstanding capital stock na siya. Or 2/3 OCS na, kasi remember, this refer to your interlocking stockholders owning more than 1/3 of the outstanding capital stock with voting rights in the managing corporation. So, managing corporation lang yan. So, yun ang kailangan yung tandaan. What else? Number 2, in case there is majority interlocking directors or trustees. So, yung managing corporation and also the managed corporation, meron silang majority interlocking directors or trustees. So remember, magbabago na naman yung voting pagdating sa stockholders or members. When it comes to BODT, majority of the quorum in both cases. Stockholders, members, majority in case of the managing corporation, but in case of the managed corporation, 2/3 OCS or members. What else? Please take note that the period of the contract is not longer than 5 years for any one term, except when there is exploration, development, exploitation, or utilization of natural resources. Managerial power. Remember, management contract cannot delegate the entire supervision or control of the affairs of the officers and business of a corporation to another corporation, as this will contravene Section 22. Please take note also of ultra vires acts under Section 44. So, ultra vires acts are acts not within the express, implied, or incidental powers of a corporation, or those that are conferred by the revised corporation code or the articles of incorporation. So, it is an act which is not positively forbidden but impliedly forbidden because they are not expressly or impliedly provided for. So, what else? Intra vires naman, transactions within the legitimate powers of the corporation related to its purposes are also known to be intra vires. So, please take note of the difference between ultra vires and illegal. So, ultra vires, hindi lang kasama sa powers ng corporation yan to do. But remember, illegal act is contrary to Lamog PP. So, hindi pwede yan. So, ultra vires acts, illegal acts are obviously ultra vires to the corporation, but not all ultra vires acts are illegal. Obviously, ultra vires acts may be ratified. Illegal acts cannot be ratified. Obvious naman yun. But ultra vires acts may be ratified. Yan. So, the first rule is that contract or act is illegal per se. It is wholly void or inexistent, cannot be ratified. So, obvious na to. What else? Contract is not illegal but merely ultra vires. Let's say is merely voidable and may be enforced by performance, ratification, estoppel, or on equitable grounds. So, that's it for Title 4 class. I will see you tomorrow, probably more examples and of course recitation. Thank you.